Hi, thank you for taking the time to review this recorded webinar on the Seattle Domestic Workers Ordinance and the Fair Employment Practices Ordinance. This presentation was created by the Seattle Office of Labor Standards and the Office for Civil Rights. My name is Jennifer Molina, and my colleague Nikki Hellenkamp and I will be serving as your facilitators today. This webinar was designed to provide you with a comprehensive overview of the Domestic Workers Ordinance, which provides labor standards protections for domestic workers, and the Fair Employment Practices Ordinance, which protects domestic workers from discrimination and harassment. These protections took effect in 2019. The primary objectives for this webinar are to ensure hiring entities and employers are 1. Aware of their obligations under these two laws, and 2. Understand how to comply with the ordinances. It is important to mention that this webinar is for informational purposes only and is not for the purpose of providing legal advice, creating an agency decision, or establishing an attorney-client relationship between the Office of Labor Standards or the Office for Civil Rights and the viewer. Any responses to specific questions are based on the facts as we understand them and are not intended to apply to any other situations. If you need legal advice, please consult an attorney. The information you'll receive is split into two different sections. The first portion will cover obligations under the Domestic Workers Ordinance, which is administered by the Office of Labor Standards. In this section, I will provide an overview of the obligations to pay at least minimum wage domestic workers, provide meal period, rest breaks, and days of rest, and provisions on keeping a domestic worker's personal effects and on retaliation. The second portion of the webinar will cover protections against discrimination and harassment under the Fair Employment Practices Ordinance, a law which is administered by the Office for Civil Rights. My goal for you is to leave this presentation with answers to the most commonly asked questions relating to the Domestic Workers Ordinance. I will discuss the essence of the ordinance, distinguish who's covered and who's not, review the ordinance provisions, provide you with useful information about the Model Notice of Rights, and of course, provide you with the must-have contact information you'll need. Without further delay, let's dive in. The National Domestic Workers Alliance reports there are over 2 million domestic workers across the United States who work in individual homes serving millions as caretakers for seniors, people with disabilities, children, and taking care of our homes. It is a large and growing workforce. By 2026, care jobs will be one of the fastest growing professions in the country. While federal labor laws protect workers from abuse by employers, they don't in fact protect all workers. The history of excluded workers is deeply racialized and illustrates the unfortunate history of labor rights in the United States. In July of 2019, a National Domestic Workers Bill of Rights Act was introduced. The proposed legislation, if passed, will extend civil rights protections to domestic workers. As of now, a total of 10 states have passed domestic workers' bills of rights, with Virginia being the 10th state to pass legislation. The City of Seattle was the first municipality to pass protections for domestic workers, followed by the City of Philadelphia. The City of Seattle passed its first labor standard in 2011. At that time, Seattle was only the fourth jurisdiction in the country to require all employers to provide sick leave benefits. The Paid Sick and Safe Time Ordinance took effect in 2012. The Seattle Office for Civil Rights was responsible for enforcing the ordinance. Between 2011 and 2015, the City of Seattle passed a total of 4 ordinances. In 2014, Seattle City Council passed a legislation creating the Seattle Office of Labor Standards to implement and enforce those city labor laws. The mission of our office is grounded in workplace equity. OLS is mandated to implement the city's labor standards as well as other ordinances that the city may enact in the future. As of 2021, the Office of Labor Standards oversees a total of 16 ordinances. OLS offers a range of services to help employers comply with Seattle's labor standards. Our services are free and private. They include trainings, resources, and labor standards investigations. We also provide interpretation and translation services for those who request them. The Seattle Domestic Workers Ordinance came from community organizing, just like all of our other labor standards. This ordinance gives basic workplace protections to domestic workers. It also requires establishing a Domestic Workers Standards Board that will make recommendations for future policy changes. According to the Seattle Domestic Workers Alliance, there are approximately 33,000 domestic workers in the Seattle area who will benefit from this. The ordinance applies to individuals, households, and companies who directly hire or employ domestic workers in the Seattle area. If you live in Seattle and you have work done in or around a home by a nanny, cook, home care worker, house cleaner, household manager, or a gardener, your home is someone else's place of work and you are considered a hiring entity. As a hiring entity, you must provide domestic workers with payment of Seattle's minimum wage, uninterrupted meal and rest breaks or extra pay if they don't get a break, 1 day off after working 6 consecutive days, the right to retain documents and personal effects, and a workplace free from retaliation. This ordinance covers both employees and independent contractors. It applies to all the types of domestic workers that were just mentioned, regardless of whether they are hourly or salary employees, independent contractors, full-time, part-time workers, and or temporary workers. It's important to highlight that a worker's immigration status does not impact the coverage or remove these protections. As a matter of policy, the City of Seattle does not ask about the immigration status of anyone using our services. A hiring entity is a person or other entity that pays a wage or pays for the services of a domestic worker. The law applies to all entities, households, individuals, partnerships, associations, or businesses that pay a wage or pay for the services of a domestic worker. This includes entities acting directly or indirectly in the interest of a hiring entity in relation to the domestic worker. Examples include, but are not limited to, any entity that has the power to determine the amount the hiring entities pay for domestic services, has the power to determine the amount the domestic workers receive for services provided, has the power to facilitate or terminate the domestic workers' relationship with the hiring entity, including the addition, removal, or promotion of the worker off an online platform, or engages a subcontractor to perform all or part of the agreed upon services. The Domestic Workers Ordinance does not cover individuals who work on a casual basis, individuals in a family relationship with the hiring entity, or home care workers paid through public funds. Casual basis refers to two different things. Number one, work that is irregular, uncertain, or incidental in nature or duration. Number two, work that is different in nature from the type of work in which the worker is customarily engaged. Whether a worker is working on a casual basis depends on the totality of circumstances. A domestic worker is customarily engaged in the type of domestic work for which they are being paid unless they voluntarily disclose otherwise to a hiring entity. Family relationship refers to the child, spouse, parent, grandchild, grandparent, or sibling of either the hiring entity or the hiring entity's spouse, or any domestic worker whose close association with the hiring entity is substantially similar in nature to a family relationship. A domestic worker is presumed to not have a close association substantially similar in nature to a family relationship unless the totality of circumstances otherwise demonstrates such a close association. Factors that might help demonstrate that such a close association exists include, number one, a personal relationship between the domestic worker and hiring entity existed prior to the work arrangement, and number two, the worker makes a voluntarily and knowing assertion acknowledging a close association substantially similar in nature to a family relationship. It's important to mention that babysitters that perform the same duties as nannies are covered by the ordinance unless they are working on casual basis or are in a family relationship with the household. A worker who is paid through public funds is excluded from coverage. This applies to local, state, and federal governments, including but not limited to Medicare, Medicaid, the Older Americans Act, and the Veterans Administration. A hiring entity is almost always responsible for ensuring compliance with the ordinance. A hiring entity is responsible if it employs a domestic worker, if it contracts with a domestic worker for services, or if it contracts with another hiring entity that contracts with a domestic worker. There is only one exception. If an individual or household contracts with another hiring entity that has an employment relationship with the domestic worker, that contractor is solely liable unless the individual or household interferes with the rights established by the ordinance. It is important to know whether a domestic worker is correctly classified as an employee or an independent contractor for two primary reasons. Number one, this will help you understand your legal responsibilities. Number two, because a domestic worker that is considered an employee as opposed to an independent contractor may be entitled to additional worker protections such as paid sick and sick leave. Under Seattle Labor Standards ordinances, an employer who classifies a worker as an independent contractor bears the burden of proof that the individual is a matter of economic reality, not an employee, because the worker is in business for him or herself and is not dependent upon the alleged employer. A household that contracts with a separate hiring entity should ask the company whether the workers are treated as employees or independent contractors to understand whether the household is responsible for compliance with the law. Even if the separate hiring entity employs or workers, the household must not interfere with the workers' rights established by the ordinance. In any event, households are encouraged to make inquiries of all contractors to ensure that domestic workers receive the rights required under the Domestic Workers Ordinance. An individual or household directly or indirectly interferes with a domestic worker's rights if it denies or interrupts a worker from exercising their rights, or knows that a worker is not receiving their rights and engages in an action or communication with the employing hiring entity that encourages the violation, or if a hiring entity discourages a worker from exercising their rights. This could look like assigning so much work that a worker could not reasonably take their meal period or rest break, expressing an expectation that the worker must skip breaks, monitoring the worker while they're on break, or encouraging the worker to accept payment below minimum wage. When two households employ one worker jointly, both households are liable for the rights of the domestic worker. This joint and several liability will likely exist even if a violation happens at one home and not the other. For example, if two families jointly employ a nanny to care for their kids, the nanny must receive at least Seattle's minimum wage in total for the hours worked. Both families must pay that total amount together, and if one family fails to pay their portion, both families are responsible. Or if two families employ a house cleaner and discrimination happens to take place at one household, both families are liable even if it wasn't taking place at the other household. To summarize, by employing one worker jointly, both households share the obligations and are responsible in the event one family fails to uphold the ordinance. The ordinance requires that Seattle households and other hiring entities ensure that their domestic workers receive a minimum wage. Every year, Seattle's minimum wage increases on January 1st. The minimum wage for 2021 is $16.69 an hour. Because most hiring entities are small employers, they must pay the minimum wage rate assigned to small employers under the Seattle Minimum Wage Ordinance, which is $16.69 an hour or $15 if the worker receives tips or employer-provided medical benefits. For example, in 2021, a hiring entity may pay the worker $15 an hour so long as the employee earns at least $169 an hour in tips or the hiring entity makes at least $169 an hour in payments towards the employee medical benefit plan. The minimum wage rate does not vary for large employers, regardless whether the worker receives tips or receives employer-provided medical benefits. A hiring entity is able to make deductions from a paycheck that go below minimum wage, but only when the worker explicitly authorizes the deduction in writing in advance for a lawful purpose and for the benefit of the worker. In order for the deduction to be valid, the written authorization must be signed by the worker, state that the worker may rescind their authorization at a future date in writing, state the effective dates of the deduction, clearly and simply state the amount and nature of the deduction, clearly and simply state that the worker authorizes the deduction from their wages, and be written in the languages that the worker and the hiring entity are most comfortable using. Under the ordinance, domestic workers have the right to receive a 30-minute meal period for every 5 hours work and a 10-minute rest break for every 4 hours work. Rest breaks are always paid, and meal periods may be unpaid depending on the circumstances. A meal period is 30 minutes of uninterrupted time when the domestic worker is completely relieved from duty. That means that the worker is allowed to rest and make personal choices as to how they spend their time during their break, like eating a snack or attending to personal business. A meal period is required when a domestic worker works more than 5 consecutive hours. The 30 minutes meal period must be provided between the second and fifth working hour. During the meal period, a worker must not be required to engage in any physical or mental exertion or be required to discuss a work task. Meal periods must be paid when a domestic worker is required to remain at the home of the hiring entity on call and ready to return to work, but is relieved of other duties. Meal periods can be unpaid when a domestic worker is completely relieved from duty and receives 30 minutes of uninterrupted time to spend at the worker's discretion. During unpaid meal periods, hiring entities cannot require the worker to have any work obligations. Domestic workers may choose to waive the meal period if their duties allow them to take an unpaid meal period. To be a valid waiver, the worker must be informed of the following in the language that the worker is most comfortable using: the effective dates of waiver, the consequences of waiving, and that the worker may rescind a waiver at any time. If the worker requests a meal period waiver, hiring entities are strongly encouraged to provide documentation of a waiver and writing with information that was just mentioned. The waiver must also be voluntary, meaning that the worker must have not been pressured or manipulated into waiving the meal period by the hiring entity. It's important to mention that domestic workers may choose to waive the meal period, but not their rest break. A rest break is 10 minutes of uninterrupted time when a domestic worker is completely relieved from work duties. As with meal periods, this means that the worker is allowed to rest, eat a snack, or drink a beverage, or make other personal choices as to how they spend their time during their break. During the rest break, a worker must not be required to engage in any discussion related to a work task. A hiring entity may not surveil a worker during the rest break. Hiring entities must allow a rest break of no less than 10 minutes for every 4 hours of working time. The rest break must be allowed no later than the end of the third working hour of the 4 hour of block time. Hiring entities are encouraged to schedule the rest breaks as near as possible to the midpoint of the 4 hours of working time. And unlike a meal period, domestic workers cannot waive the right to a rest break, and hiring entities must always pay for rest breaks. Hiring entities may require domestic workers to remain on call at the home during their paid rest breaks, provided the purpose of the rest break is not compromised. This means that domestic workers must be allowed to rest and make personal choices as to how they spend their time during their break. For more information, look at page 9 on the Q&A form located in the Domestic Workers Ordinance section of the OLS website. If a domestic worker is called back to work during a rest break or meal period, the domestic worker is entitled to restart the clock on their meal period or break. If they are unable to get 10 minutes of uninterrupted time before the fourth hour of work begins, the rest break is considered a miss. If a worker is unable to get 30 minutes of uninterrupted time before the fifth hour of work ends, the meal period is considered a miss. If the worker does not receive a compliant rest break or a compliant meal period, the worker is entitled to additional pay. For each meal period, whether paid or unpaid, a hiring entity must pay the worker for the hours worked, plus an additional 30 minutes of pay. For each missed paid rest break, a hiring entity must pay the worker for the hours worked, plus an additional 10 minutes of pay. A hiring entity may be in violation of the law and subject to additional fines and penalties if a worker misses the rest break or meal period. However, if the nature of the worker's responsibilities makes it impossible or infeasible to take a meal period or break, the hiring entity must only provide additional pay that was described and will not be subject to additional fines or penalties. It is considered impossible or infeasible for a domestic worker to take a meal period or rest break when the nature of the work does not permit a meal period or rest break without endangering the health and safety of those under the worker's care. For example, those caring for children or vulnerable adults. Or there are otherwise compelling circumstances that would have not been unforeseen by the hiring entity at the time the work responsibilities were assigned. For example, I work for a household taking care of a baby. just a couple days a week. The baby is 5 months old and does not take regular naps, nor do the typical naps last longer than 30 to 40 minutes. I am usually able to take my 10 minutes of uninterrupted time for my rest breaks during the naps. However, I am generally not able to take 30 minutes of uninterrupted time between the second and fifth hour of work, so I must then be paid for an additional 30 minutes of pay for my missed period. I may also be entitled to additional pay for missed rest breaks on day that I'm not able to get those 10 minutes of uninterrupted time. To summarize everything that we just went over, under the ordinance, domestic workers have the right to receive a 30-minute meal period for every 5 hours work and a 10-minute rest break for every 4 hours work. Rest breaks are always paid, and meal periods may be unpaid depending on the circumstances. Households and hiring entities are not required to return home and physically relieve the domestic worker from their work duties. That said, hiring entities must provide an opportunity for compliant meal periods and rest breaks. Further information on meal periods and rest breaks can be found on the comprehensive Q&A on the OLS website under the Domestic Workers Ordinance section. A domestic worker who resides or sleeps at a place of employment cannot be required to work more than 6 consecutive days for the same hiring entity without an unpaid 24-hour period of consecutive rest. Any amount of work done in a 24-hour period qualifies as a day of work. A 24-hour period of consecutive rest means that the worker is completely relieved from work duties, not required to remain at the hiring entity's home, and not required to return to work if called. A domestic worker may waive a day of rest only if the worker is aware of it and does it voluntarily. To be a valid waiver, the worker must be informed of the rights that they're waiving in the languages that they're most comfortable using, and the waiver has to include the effective dates of the waiver, the consequences of waiving, as well as the right to rescind a waiver at any time. If the worker requests a waiver, hiring entities are strongly encouraged to provide documentation of a waiver in writing with the information that was just mentioned. And for the waiver to be considered voluntarily, the worker must not have been pressured by the hiring entity. The Seattle Office of Labor Standards has made available a Model Notice of Rights in English, Spanish, and other languages. You can locate it in the Domestic Workers Ordinance section of our website. The Model Notice of Rights includes an explanation of the domestic workers' rights provided by this ordinance and a space for the hiring entity to state the established pay for the provision of domestic services. Hiring entities are not required to provide domestic workers with the Model Notice of Right. That said, OLS strongly encourages hiring entities to provide domestic workers with this information. Among other benefits, a record of providing a notice of rights may help demonstrate compliance with the ordinance if a hiring entity becomes the subject of an OLS investigation. OLS has the authority to conduct investigations and impose remedies for violations of this ordinance. However, OLS recognizes that outreach and education for domestic workers and hiring entities is the first priority. At OLS, we look forward to working closely with the stakeholders to develop enforcement procedures that will meet the unique needs of both domestic workers and hiring entities. A domestic worker can initiate a civil action to address violations of this ordinance, and the statute of limitation is 3 years. Hiring entities are prohibited from keeping any domestic workers' original documents or other personal effects. The Domestic Workers Ordinance also prohibits hiring entities from retaliating against domestic workers for exercising their rights under this law. Hiring entities may not take an adverse action, like threatening to terminate services or reporting the domestic workers to Federal Immigration Authority as a result of the domestic worker asserting their rights. It is now time to dive into the second portion of the webinar. Once again, it will cover protections against discrimination and harassment under the Fair Employment Practices Ordinance.
Hello, my name is Nikki, and I'm with the Seattle Office for Civil Rights. I'm going to talk about the City of Seattle laws that protect domestic workers from discrimination at work. Civil rights protections exist in workplaces, public places, housing, and contracting. This means that in these settings, it's illegal for people to be discriminated against based on their membership in a protected class. Today we'll be talking about civil rights protections, domestic workers, and employment discrimination. So, what is a protected class? A protected class is a group of people with a common characteristic who are legally protected from being discriminated against based on their membership in that group. For example, I am a woman. If an employer were to discriminate against me based on my sex, for example, by refusing to hire me for a job that they would prefer to hire a man for, that could be a violation of the law. The discrimination must be happening because of my membership in the protected class to be covered under Seattle's anti-discrimination laws. There are many protected classes in the city of Seattle, including race, color, sex, sexual orientation, gender identity, age, disability, marital status, national origin, ancestry, political ideology, religion, creed, veteran or military status, parental status, and retaliation. Domestic workers have the same protections as any other employees under our laws, and hiring entities have the same obligations as any other employers under our laws. This includes the obligation to ensure that domestic workers are not subject to discrimination based on their membership in a protected class. A few common types of discrimination that our office investigates include different treatment, harassment, reasonable accommodation, and retaliation. There are other types of discrimination as well. Different treatment means that a worker is treated differently in employment than another worker, and that the reason for the difference in treatment is because of their membership in a protected class. This can include pay, access to breaks, or other conditions of employment. One example would be a worker who is paid $16 an hour and finds out that a previous employee was being paid $18 an hour and believes that this difference in treatment is because she is Somali and the other worker was not. If you as a hiring entity treat employees differently, and your reason for doing so is because of their membership in one of the groups I mentioned earlier, this is likely a violation of the laws our office enforces. Another type of discrimination is harassment. Harassment is unwelcome or offensive behavior that is due to a domestic worker's membership in a protected class. To be considered harassment, the behavior must be severe or pervasive. Severe refers to how bad the harassment is, and pervasive is about how often it occurs and how long it goes on for. The employer or hiring entity knows or should have known about the harassment and fails to take action. One example would be a worker who is subjected to sexual harassment by the hiring entity, including attempts to kiss them and inappropriate touching. In this case, the hiring entity knows about the harassment because they are the person who is perpetrating it. A few more examples include nonverbal harassment, such as looking up and down a person's body, derogatory gestures or facial expressions, or following someone. Visual harassment can include posters, drawings, pictures, screensavers, emails, or text messages. Physical harassment can include assaults, impeding or blocking movement, and inappropriate touching. Another type of discrimination that our office often investigates involves disability and reasonable accommodations. Disability is a protected class. A disability is a sensory, mental, or physical impairment. It can be temporary, like a broken leg, or permanent, common or uncommon, and mitigated or unmitigated, meaning that the person may or may not be using medication or assistive devices to address the symptoms of the disability. Reasonable accommodations are changes to tasks or workplace setting that enable a qualified employee with a disability to perform the essential functions of the job. One example would be a worker with a physical disability, which makes it difficult to stand continuously for 10 minutes in one spot while washing the dishes. They can still wash the dishes, but need to break up the 10 minutes of continuous standing. An accommodation in this situation could be a chair. It could be breaking the task up into smaller parts. It could be using the dishwasher instead of hand washing. If a domestic worker has a need for a disability-related accommodation, it is the hiring entity's responsibility to work with them to see if there is a reasonable change that can be made to allow them to perform their work. If a hiring entity refuses to have a dialogue about this or denies a reasonable request, this is something that our office could potentially investigate. Finally, another type of discrimination that our office may investigate is retaliation. Retaliation is a word that people use in common language, but the type of retaliation we're talking about today requires objecting to discriminatory practices protected under the law, for example, by reporting discrimination, filing a complaint with an agency, or participating in a discrimination case. One example would be if a domestic worker was fired after telling the hiring entity they believe they were discriminated against based on their religion or membership in another protected class. If a claim of discrimination meets all of the required criteria, our office can investigate the case. The charging party, who's the person bringing forward the complaint, would sign a formal version of the complaint, and our office would contact the hiring entity. An investigator would go over the case in detail, would conduct interviews, and would gather evidence. If the investigator found that the evidence showed that discrimination occurred, they could assess damages, including making the charging party financially whole, and requiring that the hiring entity put measures in place to prevent future discrimination. If a case is opened, it's assigned to an investigator. The investigator is an impartial fact finder. They are not an advocate for either party and will not argue on behalf of the domestic worker or the hiring entity. The investigator can assist in resolving disputes and will confirm that our office can investigate the case. The investigator applies the legal elements and weighs the evidence to determine whether the majority indicates that unlawful discrimination occurred. The investigator then recommends a finding to the director, who reviews and finalizes the decision. Our office is happy to answer questions from hiring entities and provide technical assistance to hiring entities who would like information about their responsibilities under Seattle's anti-discrimination laws. To contact us, call 206-684-4500 or email discriminationquestions@seattle.gov or visit our website at www.seattle.gov/civilrights. And with that, I'll hand it back over to Jennifer with the Office of Labor Standards.
I hope that after this comprehensive overview, you are now able to understand how to comply with these ordinances. For further guidance, feel free to contact us directly. The OCR and OLS staff will be more than happy to answer all of your questions to the best of our ability. To get in touch with the Office of Labor Standards, please call us on 206-256-5297, or you can email us at laborstandards@seattle.gov. This concludes the webinar on Seattle's Domestic Workers Ordinance and Seattle's Fair Employment Practices Law. At the City of Seattle, we want to work with hiring entities to make sure they understand the responsibilities under these ordinances. Please do not hesitate to reach out to us with your questions. On behalf of everyone in the Seattle Office of Labor Standards and the Office for Civil Rights, thank you for your time and enjoy the rest of your day.